Hey everyone, welcome back. If your business final is tomorrow, this is the only review you'll need. We're covering chapters 13 through 19. This will be actually showing up on your test, so let's get into it. So, chapter 13 is all about consideration. Consideration is basically the value exchanged in a contract. Both sides must give something up. So, for it to be legally sufficient value, the promise to do something you're not legally required to do, or promise to not do something you have a right to do. When consideration is lacking, is when there's a pre-existing duty, which means you're already obligated by law to do it, so there's no new consideration. It's past consideration, which means something already done that doesn't count, or an illusory promise, which means no real commitment. So, let's get into settling claims. There's 3 ways: through accord and satisfaction, liquidated debt, and unliquidated debt. So, no consideration but still enforceable. These are promissory estoppel, promises to pay barred debts, and charitable subscriptions. So there's 5 elements to promissory estoppel. There's a promise, there's a reliance, substantial, reasonable, and injustice avoided only by enforcement. Okay, so next let's get into chapter 14, capacity and legality. Contractual capacity is the ability to enter a contract. Who lacks capacity? Well, minors, intoxicated persons, and mentally incompetent persons. So minors, they can disaffirm contracts, which means they can cancel contracts. And once they do, they must return goods, sometimes only what remains. And exceptions to these are necessaries. So, intoxication. The contract is only voidable if the person didn't understand the terms. So, mental incompetence. If adjudicated, it's void. If not, it's voidable. So, illegal contracts are generally unenforceable. Exceptions: justifiable ignorance, protected classes, and withdrawal from a legal agreement. So, chapter 15 is all about consent. Voluntary consent equals real agreement. 4 problems. We have mistake, misrepresentation, undue influence, and duress. So, mistake. It could be unilateral, which is usually enforceable, or bilateral, which means it can void the contract. Misrepresentation. It could be fraudulent, which is the contract is voidable and damages are to be paid, or innocent, which means the contract is voidable. And there's duress, which is threats, right? So threats force agreement, the contract becomes voidable. And then we have adhesion contracts. These are the take it or leave it agreements and are often enforced but scrutinized. Chapter 16 is all about the writing requirement. So, what's the Statute of Frauds? The Statute of Frauds is basically saying that certain contracts must be in writing. So, there's 5 types of contracts that must be in writing. We have marriage, 1-year rule, land contracts, executor promises, and sale of goods, which are worth $500. Okay. So, exceptions are partial performance, admission in court, promissory estoppel, or specially manufactured goods. Valid writing must include essential terms, signature of party being sued, that's it. And then we have chapter 18, performance and discharge. Performance means fulfilling duties, and discharge is when the contract ends. So, what are the conditions? Conditions, there's 3 of them, are the precedent, which must happen first, the subsequent ends the obligation, and the concurrent happen at the same time. So what's substantial performance? Substantial performance is basically work done in good faith with no major deviation from the contract terms and same overall result. Satisfaction contracts. Okay, so if it's personal, it's subjective. Others, we use the reasonable person standard. Okay, so material breach. Basically, this is a major failure which leads to the other party being accused. Okay. So discharge by agreement. This is done by 4 ways. We have mutual rescission, novation, settlement, accord, and satisfaction. So, and then we have discharge by law. Discharge by law is through alteration, statute of limitations, bankruptcy, or impossibility. Okay, now we are in chapter 19, breach and remedies. Okay, so there's 4 types of damages. We have compensatory damages, which are direct losses, consequential, which are indirect losses like lost profits, punitive, these are rare, but punishment basically, and nominal, which means only in name. And these nominal damages are a small amount. Okay, then we have equitable remedies. What are these? Rescission, which means canceling the contract, restitution, which means restoring value, and specific performance, which means the force completion. Okay, what's a waiver? Well, the waiver is giving up a legal right. Past breach is forgiven, and future breaches are not automatically waived. So, if you remember nothing else, consideration is value exchanged, capacity equals ability to contract, consent must be real, some contracts must be written, performance ends contract, and breach is usually leads to remedies for the non-breaching party, which comes in money or equity, and that's your final review. So if you made it this far, you're in a strong position. Rewatch the sections you're unsure about and walk into the test ready. Good luck, you got this. And if you have any other questions, watch this section that you're unsure about, because I posted videos on each section. Good luck, and I'll see you tomorrow. Bye.